a 7-2 emergency decision from the Supreme Court of the United States was issued during the night, and by the following morning, many Americans were unaware it had even happened. Consider the significance of that moment. 7 of the 9 justices serving on the nation's highest court released what legal observers are already describing as one of the most important structural decisions in a generation. Yet the ruling failed to dominate headlines. It was overshadowed by celebrity stories, partisan conflict, and the daily cycle of controversy that often draws attention away from developments capable of changing the direction of the country. The case centered on the Supreme Court's 7-2 emergency ruling concerning nationwide injunctions. For years, nationwide injunctions have remained one of the most controversial tools within the legal system. Critics argued that they had evolved beyond a traditional judicial remedy and had become a political weapon. Both major political parties relied on them whenever democratic processes produced outcomes they opposed. The process was straightforward. If a legislative battle ended in defeat, if a political coalition could not be assembled, or if voters supported a different outcome, opponents often turned to the courts instead. Attorneys would search for the federal district court most likely to deliver a favorable result. Once a lawsuit was filed and an injunction granted, a single federal judge in one location could effectively halt a law, executive action, or policy across the entire United States. A case brought by only a small group of plaintiffs could suddenly affect all 330 million Americans. Critics maintained that this was not the constitutional structure envisioned by the nation's founders. They argued that the system had drifted far from the principles on which American democracy was designed to operate. What made the situation even more striking was that many participants in the legal system already recognized the problem. Legal scholars, judges, attorneys general, and government officials frequently criticized nationwide injunctions when issued against their preferred policies, while supporting them when they produced favorable outcomes. Despite widespread awareness of the concerns, the practice continued because it was effective. Eventually, the Supreme Court concluded that the issue could no longer be left unresolved. To understand why the justices acted through an emergency order, rather than following the court's traditional and lengthy process, it is necessary to examine what had been occurring in the lower courts. During the weeks and months preceding the ruling, several states filed challenges in federal court. They raised constitutional objections to what they described as an expanding pattern of federal overreach. These challenges did not come from fringe groups or outside activists. They were brought by sitting governors, state attorneys general, and state legislators. These elected officials argued that federal agencies were issuing rules and directives through emergency powers and executive authority in ways that effectively altered state law without legislative approval, without a democratic vote, and without direct accountability to the people affected. The states considered these constitutional concerns serious and deserving of full judicial review. According to the account presented in these cases, the response they received deepened their frustration. Rather than limiting their actions to the specific disputes before them, lower federal courts issued nationwide injunctions that blocked state laws on a broad scale. The states had entered court arguing that federal authority had exceeded constitutional limits. In response, federal courts used their own authority to prevent state laws from taking effect nationwide before a complete evaluation of the merits could occur. Critics viewed this as evidence that the federal judiciary was no longer acting solely as an independent check on executive power. Instead, they argued that nationwide injunctions were being used as a powerful mechanism capable of stopping state governance before the underlying legal questions had been fully resolved. The Supreme Court concluded that this was not merely an isolated incident involving a single judge. The justices saw a broader pattern. Lower courts were repeatedly issuing expansive nationwide orders that extended far beyond the particular injuries alleged by the plaintiffs appearing before them. The court had previously signaled concern about this issue. One example came in Labrador v. Poe, where limitations on the scope of lower court authority had already been discussed. Those signals, however, did not end the practice. As a result, 7 justices issued an emergency order that altered the framework governing federal courts throughout the country. The language used by the justices attracted immediate attention. Justice Neil Gorsuch authored a concurring opinion. Although he agreed with the majority's outcome, he chose to explain his reasoning separately. Within that opinion, Gorsuch delivered a statement that quickly became one of the defining legal observations of 2026. He wrote that lower federal courts issuing sweeping nationwide injunctions were acting like lawmakers rather than judges. A sitting member of the Supreme Court of the United States examined the conduct of federal district judges and concluded that they were no longer operating strictly in a judicial capacity. According to that view, they had begun performing the role of lawmakers. Not elected lawmakers, not officials accountable to voters, elections, or any democratic institution. Yet their decisions were producing nationwide policy consequences, affecting the entire country based on lawsuits filed by small groups of plaintiffs within a single jurisdiction. Justice Neil Gorsuch expanded on that concern. He argued that courts should return to what he described as the traditional boundaries of equitable relief. Under that long-standing legal doctrine, judicial remedies should match the specific harm experienced by the specific party appearing before the court. If harm is inflicted on one individual, a judge may order that conduct to stop as it relates to that person. What a court should not do, according to this reasoning, is use one lawsuit to prohibit conduct toward 330 million people who were never involved in the case, never established standing, and may not share the same circumstances. Gorsuch's position was that such action is not a judicial function. It is policymaking. And policymaking, he argued, belongs to branches of government that remain accountable to the citizens who must live under those decisions. Justice Sonia Sotomayor, one of the two dissenting justices, offered a different perspective that she believed deserved serious consideration. Her concern was practical. If injunctive relief protects only the plaintiffs who bring a lawsuit, the result could be a fragmented legal environment. The same federal law might remain enforceable in 20 states while being blocked in 30 others. Rights established through federal rulings could depend entirely on whether an individual happened to be a named participant in a specific case. That could create uneven enforcement and conflicting legal realities among people governed by the same federal system. These concerns were acknowledged as legitimate. However, the majority remained unconvinced. Their position was that the system defended by Sotomayor, one built around broad nationwide injunctions, did not eliminate inequality. Instead, it shifted inequality into a different form. Under that structure, national policy could be shaped not through elections or legislation, but through access to stronger legal teams, greater financial resources, and the strategic ability to file lawsuits in favorable jurisdictions. The majority concluded that such an outcome was also inconsistent with justice. At that point, the issue moved beyond legal theory and into matters affecting everyday life, including family decisions, economic circumstances, local communities, and the policies governing individual states. Immigration provides a clear example. During the past decade, immigration became one of the most heavily litigated policy areas in the country. Nationwide injunctions repeatedly served as the preferred legal tool when administrations faced unfavorable court outcomes. During the administration of Donald Trump, travel ban measures were halted through nationwide injunctions issued by district court judges only days after executive orders were signed. During the administration of Joe Biden, immigration enforcement priorities encountered similar nationwide injunctions coming from the opposite direction. The result was years of policy reversals, legal uncertainty, and governmental gridlock. The constitutional questions involved were significant. Yet both sides frequently found it more effective to seek favorable judges than to pursue lasting legislative compromises. Under the framework established by the Supreme Court, that strategy becomes much more difficult. A state's entire immigration enforcement system can no longer be easily suspended through a court order arising from plaintiffs who have no direct connection to that state's particular circumstances. The implications also extend to firearms policy. Regardless of individual positions on gun legislation, numerous states in recent years enacted major firearm-related measures. These included expanded background checks, restrictions on assault weapons, and red flag laws. Again and again, federal lawsuits challenged those laws. In many cases, nationwide injunctions stopped implementation not only within the state involved, but more broadly as well. That situation has now changed. A state adopting a gun law may have a greater opportunity to enforce it, while legal challenges continue through the judicial process. Election law represents another area directly affected by the ruling. Election disputes involve constitutional rights, political interests, and fundamental questions regarding voter participation and election procedures. Nationwide injunctions have been used extensively in conflicts involving voter identification requirements, absentee ballot policies, redistricting disputes, and early voting regulations. Both sides frequently sought broad national injunctions whenever favorable rulings appeared possible. The Supreme Court's decision makes it substantially more difficult for a single lawsuit to suspend election rules across the country. As a result, election policy disputes are expected to return more heavily to the venues where they traditionally belong: state legislatures, Congress, and ultimately the ballot box. Environmental policy is another area facing significant consequences. Issues such as the Clean Power Plan, methane emission standards, water quality requirements, and protections for endangered species have all, at different times, been delayed or blocked through nationwide injunctions. For those relying on federal courts to advance environmental protections that Congress has not enacted and state legislatures have not preserved, that approach has become considerably less dependable. The battleground shifts toward legislatures. That shift places greater emphasis on elections, and that means greater emphasis on voters. Meanwhile, political reactions to the ruling began emerging immediately. The responses from major institutions revealed much about who benefited from the previous system. Following the decision, the White House and the Department of Justice released carefully worded statements. There was no dramatic celebration. There was no public outrage. There was no detailed policy declaration. Instead, officials stated that they were reviewing the court's order and evaluating its consequences. The language reflected an institution attempting to absorb a major structural setback without openly acknowledging its impact. According to individuals working within the Department of Justice, one word was reportedly being used in private discussions to describe the ruling. Earthquake. That was the term. Because the Supreme Court's action was viewed not as a minor procedural adjustment that could be addressed through creative legal arguments. It represented a structural transformation in the way the federal government can rely on the judiciary to advance policy objectives. And government attorneys understood the significance immediately. While federal agencies and national institutions were still evaluating the consequences of the ruling, state attorneys general moved quickly. Within hours after the decision was released, attorneys general from several states submitted supplemental briefs and ongoing litigation. They cited the Supreme Court's ruling as direct support for arguments challenging what they viewed as federal overreach. Those legal teams had anticipated the possibility of such a decision. Once it arrived, they acted immediately. At the same time, a contradiction that had existed for years became difficult to ignore. The ruling does not grant an advantage to one political party. It does not permanently strengthen a single ideology. Instead, it alters the legal framework for everyone. That distinction matters because both major parties spent years relying on nationwide injunctions as an alternative to governing through the normal democratic process. When Democrats occupied the White House, Republican state attorneys general frequently sought nationwide injunctions to stop progressive federal regulations. When Republicans controlled the executive branch, Democratic state attorneys general pursued the same type of injunctions to halt conservative federal initiatives. Each side defended the practice when it served its interests. Each side criticized the practice when it benefited opponents. The Supreme Court delivered a message that applied equally to all participants. National policy cannot be created simply by locating a favorable judge in a favorable jurisdiction. If political leaders wish to govern, they must win elections. If they seek policy change, they must pass legislation. The responsibility belongs within the democratic process. That principle applies across the political spectrum. The strong reactions emerging from certain corners of the political world reveal how heavily some groups had come to depend on a shortcut that no longer exists. Looking ahead, the immediate future remains uncertain. The first point to understand is that this emergency order is not the court's final and comprehensive ruling on every issue connected to nationwide injunctions. The underlying cases now return to lower courts. Those courts must apply the new, narrower standard to the specific disputes before them. They will be doing so under intense scrutiny. Federal judges throughout the country understand that the Supreme Court is paying close attention. Any sweeping nationwide injunction issued without detailed and rigorous justification risks being reversed quickly and publicly. The federal government is also expected to respond. Officials will likely identify test cases in which they can argue that national interests justify broader forms of relief even under the newly established framework. Differences among federal appellate courts are also expected. Some circuits may interpret the new standard one way while others reach different conclusions. Those disagreements will eventually create circuit splits, forcing the Supreme Court to revisit the issue through a full merits review. For that reason, this ruling marks the start of a lengthy legal adjustment rather than the conclusion of the debate. Yet one reality is unlikely to change. Through a 7-2 supermajority that crossed ideological boundaries, the Supreme Court publicly declared that nationwide injunctions should not function as instruments of political combat. That statement carries consequences. It affects the advice attorneys provide to clients. It influences the legal strategies developed by advocacy organizations. It alters how federal agencies evaluate risks when introducing new regulations. It changes how states assess potential legal challenges when adopting controversial laws. The strategic foundation of legal activism in the United States has shifted. Legal professionals across the country understand the significance of that change. There is also a broader implication. For many years, and arguably for decades, both political parties became increasingly comfortable with a federal judiciary that accumulated authority beyond what many believed the Constitution originally contemplated. This did not necessarily occur because judges acted improperly or because lawyers acted in bad faith. In many cases, it happened because the arrangement was convenient. National policy goals could be achieved without the difficult process of building durable democratic majorities. Major changes could occur without first persuading the broader public. Political victories could be secured without the demanding work of governing. According to this interpretation, the Supreme Court has now closed that path. 7 justices, appointed by presidents from both political parties and representing different judicial philosophies, concluded that American democracy had drifted away from its intended structure. They chose to move it back toward what they viewed as the constitutional design. That design is more demanding. It requires greater effort from elected officials. It requires greater participation from citizens. It does not allow major national outcomes to be determined solely by the most creative legal theory or the most strategically located courthouse. Such a system is less convenient. Results may come more slowly. People on every side of political debates will experience frustration at different moments, yet supporters of the decision argue that it is more transparent. They argue that it carries greater legitimacy. And they argue that it more closely reflects the democratic principles generations of Americans have been taught to value. The Supreme Court can establish a constitutional boundary. What it cannot do is compel public acceptance of that boundary. That responsibility belongs elsewhere. It belongs to voters. It belongs to citizens. It belongs to Americans paying attention and deciding whether self-government is worth the effort required to sustain it. The Supreme Court's 7-2 emergency ruling on nationwide injunctions represents a major turning point. Not because every problem has been resolved, not because every political conflict has ended, but because a nation that increasingly relied on courtrooms to answer its most difficult political questions is now being directed back toward the institutions where those questions were traditionally meant to be addressed. In legislatures, in elections, and through the direct participation of a self-governing people. That is the significance attached to what has taken place. If you found this analysis valuable, share it with others who may want to understand the implications of this ruling. Leave your thoughts on which policy area, immigration, guns, elections, or the environment could experience the greatest impact from this decision. Stay engaged with the issues that shape public life, because the developments that matter most are often the ones that receive the least attention. Please leave your thoughts about this content in the comments below. Thanks for watching. See you in the next one.